Canada, a country that spans nearly 10 million square kilometers. Founded in 1867 under the British North America Act, passed by the UK Parliament. Canada has a deep and often tragic history. In recent years, the federal government has had to recognize the harm it itself has done to Indigenous people through their oppressive policies and blatant racism it had practiced going back for centuries.
Before I took grade 12 Native Studies 30 in high school, I had no idea any of this had existed. It is so under-talked about in the media and throughout primary education that if I hadn't taken a course specifically about Indigenous studies, I never would have learned about it. I think about all the schools that don't offer Native Studies 30 as a course, and I can't help but feel it is one of the leading causes of why people in Canada continue to hold racist views towards First Nation and Métis people. Even with taking the Native Studies 30 course, I didn't realize how close to home it had actually affected. I thought, oh, it's an Ontario or a British Columbia issue. Surely there wouldn't be any land claims near me. And then when I looked into it out of curiosity, I realized there are actually several here in Saskatchewan. James Smith Cree Nation is only about 30 minutes from the town I grew up in, and despite how close it was never mentioned once that they were involved in a land dispute with the Government of Canada.
James Smith Cree Nation is located 58 miles north of Prince Albert, Saskatchewan. James Smith, the man who the nation was named after, came to Saskatchewan from St. Peter's Reserve in Manitoba, arriving in 1875. He signed Treaty 6 on August 23, 1876, and in 1884 the reserve was surveyed. On paper, Treaty 6 promised mutual respect and support. It included assurances of land, education, healthcare, and livelihood assistance. But, as the James Smith Cree Nation would come to experience, the promises written in ink rarely translated into justice on the ground. In 1885, the Northwest Resistance erupted, a movement led by Louis Riel and the Métis people, joined by Cree and other Indigenous groups who were resisting broken promises and starvation. After the resistance was suppressed by federal forces, the Crown's relationship with prairie Indigenous communities became strained. For many nations, including James Smith's, this period marked a tightening of control, restrictions on movement, increased surveillance by Indian agents, and continued erosion of self-determination. In the wake of the resistance, Chief Saddlewater and members of the Big Head Band asked the government to join James Smith Cree Nation. Permission was granted, bringing together families who shared similar cultural roots and struggles. This was just the first of many amalgamations James Smith Cree Nation saw. Chakastepason, the chief of the Chakastepason Cree Nation, and 4 other headmen signed Treaty 6 in August 1876 at Fort Carlton. Their band resided in an area around Fort Alacorn in the late 1880s, but the Department of Indian Affairs alleged that all the Chakastepason band members had moved off their reserve by 1898, and that their names had been added to a pay list of other bands. The government claimed that they had ceased to exist as a band from that point, and the reserve was sold. Many were just put on James Smith Reserve. This became the second amalgamation. In 1902, the third and final amalgamation took place. Peter Chapman was a counselor for the Cumberland House Indian Band. and he signed Treaty 5 on behalf of Cumberland House in 1875. Shortly after signing, Chapman began writing letters to the Government of Canada requesting new reserve land for the purposes of farming. Chapman wanted land near Fort Carlton. In the early 1880s, Peter Chapman, tired of waiting for Canada's approval, struck out for Fort Carlton with a total of 7 families following. The 100A people began arriving in the Fort Carlton area in the early 1880s, setting up camp beside James Smith Reserve. In 1887, Canada agreed to survey a new reserve named Cumberland 100A. Peter Chapman's vision and dream to support his family and people through farming became a reality. Canada officially supported Chapman's farming plans by providing 6 oxen, 7 horses, equipment, and a farm instructor for the newly created Cumberland 100A band. Government officials obtained documentation for a surrender of Township 47 from Cumberland 100A First Nation. This surrender of 22,080 acres is in question because of the involvement of James A. Smart, Canada's then Deputy Superintendent General. After this surrender, former Cumberland 100A land was resold for double purchase price, and some of that land was purchased by James A. Smart himself. After the surrender of 1902, the Indian Affairs officials who took the surrender proceeded to prepare documentation for the amalgamation of Cumberland 100A and James Smith Cree Nation. The Peter Chapman descendants argue that this amalgamation was indeed invalid. Recently, First Nations people all across Canada have started to look into treaties and have taken the government to court over several broken promises. This gave rise to what are now known as specific and comprehensive land claims, the process the federal government uses today to address historical grievances.
My name is Carolyn, and I'm an instructor in the adult education program at Suncrest College. I teach a Native Studies course online through the college, and many of the students that I teach come from reserve communities such as Kiniston and James Smith. And in the past few years of teaching the course, land claims have become an increasingly important thing to teach about. Many of my students are members of reserves who have been fighting for decades for their land claims, and I feel that it's important for me as an instructor to take my students closer to home. So we spend a fair bit of time in class talking about what land claims are, what the process is like, and the specific claims that actually affect them and their communities. There are 2 separate types of land claims a band member of a reserve can make against the federal government. A specific land claim deals with historical grievances where an existing legal obligation of the Crown was not fulfilled, like, for instance, a failure to provide the correct amount of reserve land promised in a treaty, illegal disposition of reserve land, mismanagement of First Nations funds. A treaty land entitlement claim is an example of one of these specific land claims a band can file. The second type of claim is known as a comprehensive land claim. This is based on the idea that Indigenous title to certain lands was never given up or formally addressed through a treaty. These claims are more common in regions like British Columbia, Quebec, and Northern Canada, where no numbered treaties were ever signed. In these cases, land was simply taken without First Nations consent. The goal of a comprehensive land claim is to negotiate a modern treaty that defines and exchanges unextinguished Aboriginal rights and title for a comprehensive package of rights and benefits, including land ownership, financial compensation, resource management, and self-government provisions.
So unlike many reservations who have land claims, James Smith Cree Nation has 3 separate land claims. On January 24th, 1991, the James Smith Cree Nation submitted a specific land claim regarding the surrender and sale of the southern portion of Indian Reserve IR 100A. The First Nation Reserve claimed that Canada breached its statutory, treaty, trust, and fiduciary duties in taking the alleged surrender, and further argued that Canada breached these duties in its unlawful disposition of IR 100A. On March 13, 1998, Canada initially rejected the First Nations' claim regarding the validity of the surrender, while accepting for negotiation an outstanding lawful obligation with respect to the sale of the surrendered lands. The Indian Claims Commission accepted the May 18, 1999 request by the James Smith Cree Nation to conduct an inquiry. The inquest into the matter found that Canada's failure to have sought the informed consent of the whole Cumberland Band to the surrender of the southern portion of IR 100A and to the agreement to amalgamate its interest in IR 100A with the James Smith Band was a breach of treaty, statutes, and fiduciary duties. Upon the surrender of reserve land, the Claims Commission found that Canada had a treaty, statutory, and fiduciary duty in disposing of this land by sale. Canada admitted its breach of fiduciary duties in accepting prices well below the appraised value and for failing to enforce the terms of sale. Canada also admitted it breached its statutory duty for its failure to have immediately dismissed its employee for his conduct involving the sale of IR 100A and for its failure to have cancelled the sales attributable to him. In 2025, Canada and the descendants of Cumberland House Cree Nation came to an agreement. The nation was to receive $570 million. James Smith Cree Nation and Cumberland House both had filed claims over the same land, and both were looked into simultaneously by the Commission due to the unique nature of the case, as both were over the exact same land. Peter Jamin members are descendants of Cumberland House Cree Nation, who were wrongfully transferred to the James Smith Cree Nation, which is why both of these reserves had that specific land claim. In regards to the second claim I mentioned, according to descendants, the Jackastay Basin Reserve was never formally surrendered. In other words, the people never agreed to give up their lands. To this day, Jackastay Basin descendants seek re-establishment of their band and the restoration of their reserve, arguing that Canada violated its own treaty principles by taking land without lawful consent. In 1998, they filed a similar claim to the claim made in 1991 about the illegitimate sale of reserve land. In 1999, an inquest was requested by Jackastay Basin, and Canada did not raise a challenge to the inquest. In examining the James Smith Cree Nation's claim considering the surrender and disposal of IR 98, the panel found that while members of the Jackastay Basin Band were dispersed following the 1885 Northwest Rebellion, there were no valid transfers of Jackastay Basin members into the Cumberland House Band at IR 100A, nor was the panel satisfied that Canada's reliance on the 9 signatories of Jackastay Basin members at IR 100A provided consent for the whole of Jackastay Basin Band. The panel recommended that James Smith Cree Nation's Jackastay Basin Indian Reserve 98 claim be accepted for negotiation under Canada's specific claims policy. Yet, despite the inquest being requested nearly 30 years ago, the claim was not settled until August of 2025. The third and final claim was brought forward by the descendants of the original James Smith Band itself. When their reserve was surveyed in 1884, the band alleged that they did not receive the full allotment of land that had been promised under Treaty 6. The government later argued that the extra land added in 1902 following the amalgamation with Peter Chapman Band, compensated for any shortfall of the initial survey. In 2018, the community filed a treaty land entitlement. Under Treaty 6, they were supposed to be granted 129 acres per person. The reserve, surveyed in 1884, only satisfied conditions for 139 people, despite the higher population at the time. In 2025, the claim was settled, and the reserve was compensated for this oversight. This case is highly unique, which is why I found it so interesting. It's not very common that one reserve has 3 separate land claims. I find it so fascinating that it took so long to come to a settlement. How could it possibly take 30 years to settle a case? Especially when the government was so clearly in the wrong, and from all the information I can find, I actually had admitted fault. Despite admitting fault, the government still took 30 years to actually come to the agreement in this case. It's just mind-boggling to me. One reserve, 3 separate bands illegitimately amalgamated into one band. No consultation of Indigenous people in any of the amalgamations, just deciding that they would no longer have a reserve of their own. Land claims are not simply about ownership. They are about recognition. A call to honor the words written in treaty and the spirit in which they were signed. The James Smith Cree Nation story reveals how the promises of the past continue to echo into the present. The land claim process itself is complicated, often taking decades to navigate. It involves legal arguments, historical research, and deep emotional endurance. Many claims require the collection of archival maps, oral testimonies, and community records, evidence that must meet the government's high standard of proof. For communities like James Smith, this process can feel like reliving centuries of injustice within a bureaucratic maze. Yet, it is through these very efforts that Canada is forced to confront its own promises and principles. Every successful or ongoing claim becomes a record of accountability, a tangible acknowledgement that treaty rights are not symbolic, but binding obligations. It forces us to ask difficult questions. What does reconciliation truly mean if the land itself remains contested? How can justice exist when history's wounds are still open? There may never be a single answer. But acknowledging these truths, speaking them, documenting them, and learning from them is a start.